to their clients. At Leader & Leader, they offer every type of criminal defense, including DUI, federal drug charges, white-collar crime or fraud cases, theft offenses, violations of probation or early termination, and all other criminal matters from investigation to trial. Let the criminal and DUI law firm of Leader & Leader PA explore all of your options. Call them today at 954-523-2020. That's 954-523-2020. Or go to their website at criminallawleader.com. Do not take chances when it comes to your freedom or the possibility of jail or prison time. Free in-office or telephone consultations for all criminal matters. Do not hesitate. Call the Criminal Law Leader today, 954-523-2020.
And we're back. I'll tell you, we are so strong to have an addiction show, then go into a criminal DUI show. And we were talking about how lucky we've been to get the top experts. Michael can't say this. We can. The top experts. So, you know what? If you get in trouble with DUI or anything, drug possession.
Right, and be proactive and just mark down the name.
Don't Google, okay?
Right.
Don't Google. We have the experts here. We're going to give you his phone number. Michael Leader, again, as a lawyer, you can't say I specialize in something, but Michael Leader knows DUI. He knows that. And we're going to talk about the administrative side today also. So if you'd like to watch the show today, Michael's got the show on his website at www.criminallawleader.com. You can watch the show right now, or you can go back and watch it later on,
That's
too.
right. Or if you have a question for Michael Leader, you could call the studio at 888-565-1470. That's 888-565-1470, and speak to Michael directly.
Exactly. Now, some things he can't answer because he can't perform.
Well, for legalities, right.
Yes, but yeah, if you got a question, just give us a call because we have the best of the best. Hey, Michael.
Welcome to the show,
guys?
Michael.
Good to see you. Thank you. Happy to be here.
You know, if God forbid, I don't drink, but if I ever got pulled over, this is the guy I want to represent me because he's been doing this for a long time.
Or with any other criminal matter.
Yeah, exactly. How long have you been doing this for, Michael?
In total, with everything in the criminal arena, 16 years experience.
Wow.
Now, he was just talking before we went on. He wanted to discuss felonies versus misdemeanors, different offenses.
I find one of the things I want to do is there are a lot of people that are going to be listening that may not need me, may not want me, whatever it may be.
Right now.
But there are a couple of areas that I thought about that I find when I speak to people, they're very misguided or misunderstood, and I thought maybe we can correct some of those things. And I was going to also say, people may not want to call and ask questions on the radio. I offer free consultation, so if anybody that's listening has a question, they don't want to do it on air, my office number is 954-523-2020. They're welcome to call me anytime. I have a 24-hour day, 7-day-a-week answering service if we're not in, and I'll be happy to talk to anybody. If anybody wants to call on air, I'm happy to speak to them, but I can always speak to them at the office
We have
as well.
such a large area because the station is so big. So do you cover Broward, Palm Beach?
I do general criminal work typically. It doesn't make sense for me to go outside of the Tri-County area, so Dade, Broward, Palm Beach. Generally, my experience and what people would pay for me to go out of area, I'll frequently tell them to or help refer them to a local lawyer. For federal work or DUI work, I take cases all around the state of Florida. The bulk of my practice is Dade, Broward, and Palm Beach, but DUIs I get because I am known, because of my background experience. I get cases all around the state, and I find that I've been equally, if not even more effective out of area. It's kind of funny. I think that prosecutors that don't know me and aren't used to dealing with me every day, like the ones in the Tri-County area, they start seeing an approach to DUI cases that they don't see with every other lawyer. They see certain emotions. They realize that I know this probably better than they do and better than the lawyers, most of the lawyers anyway, they're used to dealing with. And frequently I found that they've buckled. In fact, the last case that happened to me on, I had to hire my investigator because I was sure it was a guy with a second arrest DUI within 5 years. There was mandatory jail time required by statute, 5-year license revocation. There was a driving pattern, all this stuff about the case. The report read terribly. And as soon as I filed motions, They're saying, will your guy take a reduced charge to a reckless driving with 3 months probation, no conviction?
Just filing?
Like ridiculous. Well, I mean, I'd filed motions for an evidentiary hearing, things of this nature, but
so obviously you didn't go for that.
well, I'll tell you what. I hired my investigator because I was convinced that there had to be some problem with the cop that I didn't know about. He was retiring. He was in trouble. There was nothing. The trooper in the case was perfectly clean. We got his entire history, his employment records. There was not a spot on it. The prosecutor just chickened out. She didn't know how to deal with what I had.
Wow.
And my client was looking at mandatory jail time. They offered him a withhold on reckless driving with 3 months probation and court costs.
So
and
most
my client
people
took it and ran.
Most people don't even know what the penalties are with DUIs. So why don't you tell people?
Sure. So there's two things. And before we get into that, just quickly, because it's a good lead-in, people think when they get tickets and they don't get arrested that it's not necessarily criminal. That's not true. Anything from driving on a suspended license, operating without a valid license, an expired tag more than 6 months, DUI, obviously, these are all criminal charges. And people go to court in front of a judge and they'll talk to me years later, oh, I had this one thing, but it was just a traffic ticket. They don't
take it
realize that they
serious,
now have a
right.
criminal record because of it. And it affects them later because they didn't realize it was criminal. I have a client now that we were trying to help get into a diversion program on something. She told me I've never had a criminal charge. But I said, well, I looked up your record, and did you go to court, 2 years ago? She goes, yeah, but that was just for traffic. I go, yeah, it was criminal. She just pled to it. She didn't know she was pleading to a crime.
Do you want to know something? I didn't even know that.
So that's the first thing. And the other thing
Do
is...
people try to represent themselves thinking it's not a major crime?
I would say less frequently on felonies, but certainly on traffic stuff frequently and DUIs. And here's the misnomer. Back in the 70s, and even the early 80s, you could get a DUI, no priors, and they would knock them down to reckless drivings all the time. That doesn't happen anymore. There are a few counties that now have diversion programs, but in some instances, those aren't good options for you. In others, they're great options depending on your case. The problem is a lot of people think, oh, I have no priors. They're just going to knock it down to a reckless driving. That doesn't happen anymore. You have to have leverage over the state unless there's an organized diversion program where your lawyer's done a good enough job or there's a problem with the state's case because the cop screwed something up or something where they think they may lose their case. They don't just offer reckless driving because, oh, well, he has no priors, perfect rest. Somebody's 38 years old, they've never been in trouble day in life. They think, oh, well, I have no history. Doesn't matter. The only history that matters with DUI is if you have other DUIs. Nothing else matters. And they're statutory minimums, which goes in to your question. One of the things that I want to talk about today is the administrative side, because when you get arrested for DUI in the state of Florida, you have two completely separate, distinct cases. One is administrative with the Department of Highway Safety Motor Vehicles, which affects your license and also can have impacts on insurance and other things. And then the other is the criminal case. Now,
but is that revocation? I mean, do they take away your license?
Yes, you could lose your license depending on the circumstances for anywhere from 6 months to several years, depending, up to 18 months generally on the administrative side, 6 months to 18 months. But the bigger issue is people don't realize that if you have 2 driving license suspendeds and then you get a DUI in a 5-year period, that can habitualize you. I just took over a case where after the woman already pled and had another lawyer, and she lost her license for 5 years. And she goes, but they told me there was only going to be a 6-month suspension. Well, I called the other lawyer when I took over, and I said, did you ever advise her that she would lose her license for 5 years to try to figure out if she knowingly and voluntarily took a counseled plea? He goes, well, there wouldn't be a 5-year because I won the administrative hearing. I go, and that has nothing to do with habitualization. And that's a guy that predominantly does personal injury work. Should never have been handling this case. He said to me, he goes, oh, my God, no, I never advised her because I didn't even know that. He didn't even understand what I was talking about.
That's why he shouldn't be handling those cases.
But tons, the majority of lawyers that take them shouldn't be and do. But anyway, so she now has a 5-year revocation of her driving privilege, and nobody ever warned her that would happen. So we're looking into vacating that plea, but that's a double-edged sword because once you vacate the plea, sometimes the judge or the prosecutor may be upset, and then if you get convicted and don't beat the case on the back end, and you could come out a lot worse. So you got to be careful what you ask for.
Even if she wasn't properly advised, though?
Well, you could potentially we can vacate the plea, but now she got a lower plea offer in that case from the judge, and the state wanted to offer. So if she vacates it, the judge says, well, I'm not getting involved this time, and the state may say, no, we want jail time.
See, this is why...
That's what I was going to say. This is why you have to call Leader and Leader.
Well, there's a lot of law firms out there
it's
that we
scary.
call boutique You know, because they do a little bit of everything.
Right.
And
Every
look what
area
just
of law.
happened to this client. This is why you need somebody like Michael Leader, because this is all they do is criminal. He doesn't have personal injury up there. He doesn't have bankrupt. He does criminal law. So he knows. Look what happened. Here's an attorney who didn't even know that they could do this at all.
And I do DUI law, and there's a difference.
You specialize in that.
Well, I do. I have a large focus in my practice in DUI. There's a period of my career that I did nothing but DUI, and I do criminal. And there's a lot of great criminal defense lawyers that don't know DUI well, because DUI is separate and distinct from criminal defense work. Most people lump it together. They think it's all the same, but there's issues and scientific evidence and factors that apply in DUI cases that you'll never see in a criminal case. And I think I mentioned this to you guys once before. One of the best trial attorneys in the state of Florida was a homicide prosecutor in Broward County. He teaches and he's an adjunct professor. He will tell students that if you can try a DUI well, you can try a murder case no problem.
Wow.
You can try anything, because people do not appreciate how complicated the scientific evidence is, what goes into the blood draws, the intoxilizer. And frankly, when it comes to there are some decent DUI attorneys that can handle a refusal case pretty well, but when it gets to dealing with the breath and the intoxilizer and blood evidence, they're lost. They're clueless.
Okay, and again, going into what we discussed this last month. So if you get stopped by a police officer, should you agree to do the breathalyzer?
Right, and as I told you, there's no definitive answer, and the problem is it varies for everybody, right? Because everybody has a different body, everybody has a different tolerance. Sometimes you don't know what you drank because you're not the one that poured the drink, and they say, oh, well, I only had one drink, but it was an 8-ounce glass with 4 ounces of vodka mixed in. That's 4 drinks in one glass,
right.
Not one drink. So it's hard to give that blanket advice. And what I would tell somebody is, if a guy like Steve or I sat down and we had a bottle of Bud Light with a steak dinner over an hour and a half, blow all day long. You're not going to blow over. But it varies for everybody, so it's hard to give blanket advice. And because it's a separate crime to refuse for a second time if you have a prior refusal, as a lawyer, I can't tell people to break the law. So I couldn't even give you blanket advice to always refuse, because I could be telling you to break the law if you had a prior refusal. But I wouldn't anyway, because there are a lot of times where maybe you should, but generally what I tell people, a rule of thumb is, if you're unsure and if you think you may blow over,
don't.
Then, well, I don't necessarily say don't, but I tell them I will probably have a much easier time defending your case with a refusal than I will if there's some confirming breath reading that says you're over an 08. Because separate and apart from impairment, they can convict you in Florida just by being over the legal limit of 08 without the evidence of impairment in theory. Now, if there's a video in the case and the person looks great, we can overcome that. There are a lot of ways. There are ways that we get the breath evidence thrown out in a lot of cases. So, I mean, that gets... Absolutely. When you know what you're doing, there's ways... Listen, the reason people don't like lawyers until they need them, a good lawyer manipulates the process. We pick everything apart, and we find ways to basically turn it on its head and use it against the other side. And that irritates the heck out of people, and I understandably so. But that's why a lot of people, make comments and negative commentaries, oh, lawyers this, lawyers that, because... if we're doing our job well, we're not just manipulating the facts. And I don't mean manipulating in a bad way, in an unethical or unprofessional way, but it's our job to turn and use everything in the best possible way for our client's benefit, including the process, procedure, the facts, the law, everything. So, yeah, there's a lot of situations where we can find things that are done or not done. But what happens is, if you do refuse or if you blow over an 08, well, and I'll tell you quickly because you asked.
And the first time I'm talking about, the first time to refuse, because I know you said something about the second time refusing. But if initially you get pulled over and you think that you had a couple of drinks, and so I'm saying that for me, I probably would refuse.
If you had 4 ounces of wine in an hour, I would say you should be able to blow and be fine.
Right.
But if you're not sure how much
That's
you
what
had,
I'm saying,
what the alcohol content, you feel, I feel all right, but I'm a little tipsy. It may not be a bad idea if you think you're going to blow over to respectfully decline, but every case is different, so I can't give people that blanket advice. And a lot of lawyers tell you always refuse, and I disagree with that. I don't think that's good advice. I think that there are times. I had a gentleman that was in his 70s, and he blew well under, and then they asked him for urine, and the urine came back negative, and it basically took me a phone call to have that case thrown out, but if he had refused, they may have filed the case. Now, I have one where they refused the breath, but then he agreed to give urine. Or, I'm sorry, he gave a breath, but then refused to give the urine. The breath was 0, and then he refused to urine. I was able to get them to throw that out completely. They never filed the charges because I was able to demonstrate that the officer never expressed any basis to ask for the urine other than, oh, well, he didn't have a breath reading, so it must be drugs. But there was no evidence of drugs.
How about a blood draw? I mean, do they make you do a blood draw?
Blood draws are an interesting issue right now because a number of months back, and maybe even a year now, I lose track of time, there's a Supreme Court opinion called, I forget if it's McNeely versus Missouri, Missouri versus McNeely, but it's a United States Supreme Court case, and I think it's McNeely versus the state of Missouri. But it basically said that you can't just automatically take blood in certain scenarios where even if there's a statute in Florida like we have authorizing it and you need a warrant, or unless you can demonstrate exigent circumstances, that there's some urgency that they can't wait for a warrant or the evidence would be gone. And the Supreme Court said no, that the prosecution wants us to say that a per se rule exists in DUI, that it's always exigent. And we're not willing to say that. So unless on a case-by-case basis they prove exigency, then you need a warrant to get the blood. And I have some DUI manslaughter cases right now, one of them in particular, that I'm hoping I may be able to use that to help get the blood thrown out in the case, as well as other issues. And if the blood goes away in that case, then my client's case goes away. That's a unique case in the sense that I know my client did have a blood alcohol reading, but I honestly think there's issues with the blood, and I really don't think my client was guilty. I mean, there's a difference between a client being not guilty, meaning the state can't prove their case, and innocent. I suspect my client may actually be innocent in this particular case. But
we got to go to break. When we come back, I want to talk about BUI, because you hear about all these stories.
That's a big thing right now in the news.
People who are in boats that are gotten pulled over, and I also want to talk about what it's like going to jail.
I can't answer that one, thank God.
Yeah, but you hear from your clients. I mean, maybe we can deter someone from taking that drink and going out and being pulled over. So we'll be right back with criminal attorney Michael Leader of Leader & Leader Law Firm.
When you need an aggressive, experienced, and knowledgeable criminal or DUI defense attorney, turn to the law firm of Leader & Leader, PA. With nearly 80 years of combined experience, Michael D. Leader is a former prosecutor with considerable experience, not just in all areas of criminal law, but also DUI defense. Michael Leader has dedicated his entire practice to the art of defeating DUI and criminal cases for a period of time. The criminal and DUI defense law firm of Leader & Leader, PA has a remarkable track record. They develop a close working relationship with each of their clients prior to deciding how to proceed with your case in order to tailor the approach and defense to each individual client and their needs. They are always available to their clients. At Leader & Leader, they offer every type of criminal defense, including DUI, federal drug charges, white-collar crime or fraud cases, theft offenses, violations of probation or early termination, and all other criminal matters from investigation to trial. Let the criminal and DUI law firm of Leader & Leader, PA explore all of your options. Call them today at 954-523-2020. That's 954-523-2020. Or go to their website at criminallawleader.com. Do not take chances when it comes to your freedom or the possibility of jail or prison time. Free in-office or telephone consultations for all criminal matters. Do not hesitate. Call the Criminal Law Leader today, 954-523-2020.
And we're back. God, I could just sit here and listen to Michael for 2 hours. I mean, he's just so up on what is happening today. We're here with attorney Michael Leader of Leader & Leader Law Firm. Give everybody your phone number. Listen, write this number down because you never know, either yourself or a friend or a family member needs a good representation.
24 hours a day, 7 days a week. We can be reached at 954-523-2020 and always online at www.criminallawleader.com.
And you can actually watch the show on Michael's website.
You can go back and watch today's show, too.
Yes. Give everybody your website address.
Again, that's www.criminallawleader.com. And guys, before we move on, let me just hit 2 quick points because, you know, I'm a lawyer. I like to talk. And I never really got to answer two questions. And first, in Florida, you could literally be joyriding in a stolen car, get charged for felony grand theft, and walk away easier than you can DUI. There's statutory minimums. First offense, no enhancements, the most basic case. You're looking at a minimum mandatory of a conviction that you can never get off your record and never have sealed or expunged or have anything else sealed or expunged because you have this on your record. You're looking at anywhere from $1,000 to $2,000 in fines. You're looking at anywhere from $450 to $680 in court costs on top of that. You're looking at a 12-hour DUI school plus counseling sessions for 8 to 16 weeks afterwards, all at your own expense. An interlock, a boot on your car that you have to pay for them to do. If your breath is enhanced or over a 0.15, they'll require a minimum of 6 months of a device that has to be in your car you blow into to start. There's mothers against drunk driving. Some judges will require AA meetings. You'll have 6 to 12 months probation, 6 to 12 months license suspension, 50 community service hours. That is the statutory minimums for the most part on a DUI, first time offense.
And the crazy thing is, especially with the holidays, and we were just talking about that, I mean, most people go out and they'll go to, say, Thanksgiving or holiday party, and they'll have, 1 or 2 drinks, and they're feeling pretty, they're feeling fine. But you never know how you're going to register if you're driving and something happens or you get pulled over.
It's interesting because I think that when you participate in the business side, they have something called wet labs where they'll have you drink and blow and watch you going up and see how you feel at certain levels. And from the experiences I've had involved with that as a prosecutor and a defense lawyer and people I've talked to, when they get even close or above the legal limit, there's no question they know. But I've been involved with thousands of DUI cases over the years, and from speaking to real people in everyday life, now I'm sure some people aren't always fully honest or maybe they don't remember well, but it's the range of what people tell you about how they felt and people's utter shock and dismay. But that they blew over because they said, I felt perfectly fine.
Right,
now,
that's exactly it.
Sometimes it's hard for me to believe, and I would tell you on the old machine they used in Florida for the breath testing, I rarely ever saw cases where I said, I'm not so sure that that's accurate. But they switched a number of years back to a newer model, the 8000, and I've had much more cases with the 8000 the 5000 where I've believed for numerous reasons the information I had, what clients were telling me, what witnesses were telling me, and the breath result just didn't add up. So there have been a number of situations where I think the breath result has been very unreliable, but I will say that the science and technology behind these is not garbage. I mean, there is some merit and basis to it, and sometimes they are accurate. I'm not saying it's all junk science, but I've had too many cases over the years that just didn't add up, and they're giving them this breath reading, and you see the person on video, and people say,
so how do those hold up in court?
Well, cases where there are videos, I don't care what the other evidence is. If I have a client that looks perfect on video, I'll take that case to trial all day long. I can't remember ever losing a case with a good video. In jurisdictions where they use the video recording and there's a video of your client and your client looks great, we get jurors here in Florida.
Is this with like roadside exercises? Because I know sometimes they stop you.
It can be, some of them have it, officers have it, where as soon as they go to stop you, it films you driving, films the stop, films everything from A to Z. And there are others that it's only back at the police station for breath testing and a second set of roadsides. Sometimes it's at the road. It varies. And in Miami-Dade County, for example, they hardly use them anywhere. And then in Broward and Palm Beach, it depends on where you are, which agency, things like that. So, and then around the state, it varies as well. But yeah, I mean, so when you have a video and you look great on video and you have a high breath reading, I had a client with a 3.2. I mean, off the charts. And he looked perfect on video. The prosecutor right before trial knew me, knew my reputation, knew my background. They hadn't watched the video. They finally watched it right before trial, and they came back and they said, well, your guy taken off for something other than a DUI. They had a breath reading 3 times the legal limit.
That's crazy.
And they knew
this is what happens when you have the best attorney.
Exactly.
So, but anyway, so the other component, though, that we need to, people need to be aware of, because even if you get a public defender, they don't handle the administrative side. And what happens is when you get arrested for DUI, if you blow over an 08 or you have refused, you're looking at anywhere from a 6 to 18 month suspension of your driving privilege.
Wow.
You have 10 days from the date of your arrest to challenge that or to file for what they now have, a waiver where you may be eligible to get a hardship, a business purpose license. If you don't act within that 10-day period, you're done. There's nothing you can do. So that's the thing that people don't often realize. You get a ticket. If your box is checked off on the ticket that says eligible for permit, that DUI ticket's your license for 10 days. But midnight on that 10th day, if you've not acted and done what you need to do, you've waived your options and you're stuck with that suspension.
Wow. That's crazy.
You know, that, and even if you have, you know, and here's the other problem. I want to be so clear that I'm not knocking public defenders. They do a great service for the community, for our people, for people that are charged with crimes, for people that can't afford private lawyers. But the problem is most of them are burdened with more cases than any lawyer should reasonably handle. And the ones that are handling DUIs in most jurisdictions are normally baby lawyers that have been out of law school literally a week to 6 months to a year. So they may be the next Johnny Cochran, but at the time they're handling your case, they're probably overburdened and don't have enough experience yet. So that's the only problem as it relates to DUIs in my mind with public defenders. Now, again, there are supervisors or special circumstances, and I'm not knocking public defenders at all. It's just a matter of experience and time.
I want to ask you, because I know we're getting ready to go. Are roadblocks, are those legal? When they have these, where they do the testing?
They can be, but there's a lot of ways to challenge them because and a lot of lawyers don't know the way to challenge these and they blow it. I have a case for a client. We won his administrative suspension, and then we were able to get his case. We could have gone forward. I told him if we went forward with the hearing, I thought we would win and we get his case thrown out. He didn't want to take the risk because a judge could give you a bad ruling, then he has to appeal everything else. He got a reduced charge. It was, I think, to a careless driving. I don't even think it was a civil infraction. It wasn't even a criminal charge. And he elected to take that resolution instead of going forward. But yes, we can absolutely win on those issues. And a lot of lawyers that don't know this well enough don't know how to win on those issues.
Folks, we have the best. Doesn't mean he's the most expensive. We have the best criminal attorney. And if you or a family member or even a friend, Michael Leader. Give
your phone number.
954-523-2020. And you make a good point. I'm not the cheapest, but I'm nowhere near the most expensive.
So listen, write this down, okay? Mike will be back with us next month. I love talking to him. I could just go on forever. Thanks for coming in today.
Thanks, Michael, for coming in.
It's always a pleasure.
We'll see you again on Friday.
4 o'clock.
More Ask the Experts, 4 to 5. See you then. Peace and love.
We're out.
Thanks for tuning in today to the Ask the Experts show with Steve-O and Renee. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed